Just Stop Oil's founder, Roger Hallam, has been sent to prison for 5 years for conspiring to cause public nuisance by disrupting the M25. And 4 co-conspirators were each given 4 years, so a combined 21 years for the 5 involved in the disruption. But here is the stuff that much of the media seems to have missed out. 5 climate activists from Just Stop Oil have been given what is thought to be record custodial sentences for their involvement in a conspiracy to cause public nuisance under the new Public Order Act of 2023. And I've seen all sorts of comments about this, both in the news and on X, and many of which seem to miss many of the points raised in the sentencing remarks by the judge. So I thought it was very important that anyone that has any thoughts about this or casts any views about this, hear what those sentencing remarks actually say. I've even seen comments that suggest that they were given these sentences purely for attending a Zoom meeting. That's obviously not the case. Now, first of all, the new law is the Public Order Act 2023, specifically Section 7, which is designed really to deal with exactly this kind of offence. And it's been created as a specific offence: interference with the use or operation of key national infrastructure, where a person commits an offence if they do an act which interferes with the use or operation of any key national infrastructure in England and Wales, and they intend that act to interfere with the use or operation of such infrastructure, or are reckless as to whether it will do so. The defence, which is one of the things that people have been talking about, is whether they have a reasonable excuse for the act mentioned, or that the act mentioned of that section was done wholly or mainly within contemplation of furtherance of a trade dispute. Now, that aside, the Just Stop Oil activists have been filmed being arrested, as shown here on X. The police turned up to arrest them for the conspiracy, which is a plan between multiple people to carry out this offence. And then there was a protest which was filmed after a prison van believed to be holding Roger Hallam and 4 other activists after receiving these long sentences. Now, as I said, the discussion over on X and in various other places has split opinion somewhat, with some reporters, Robert Peston here, saying things like the following: is conspiring to stop the traffic in the cause of raising alarm about climate change deserving of custodial sentences of 5 and 4 years when so many crimes of violence and thefts go unprosecuted and our prisons have run out of capacity? Does anyone think these sentences do credit to our justice system? I'm bemused. And then many prominent legal professionals have, in my view, quite rightly pointed out that there has been poor reporting of why the judge in the Crown and Hallam passed the sentence that he did. It would be helpful, Barrister Faisal Sadiq says, if journalists at least read the sentencing remarks, linked below, and then explained which bit of the judge's reasoning they took issue with. And therefore, I too thought it was very important that anyone that has any views and casts any views on these sentences, that they actually understand the sentencing remarks and the judge's position. This is why, and it's very important with modern media coverage, that judges put down in writing the reasoning behind their sentences. We refer to these as sentencing remarks. It's the reasoning and the approach that the judge has taken to passing these sentences. So first of all, the judge says, I have to sentence all 5 of you for the offence of conspiracy intentionally to cause a public nuisance, of which you were each convicted by the jury following a trial which concluded a week ago. The conspiracy in question involved a sophisticated plan to disrupt traffic on the M25 motorway by means of protesters climbing up on the gantries over the motorway. You probably remember some of those photographs of the Just Stop Oil activists above the motorway, the M25, on that gallantry, which then disrupted the traffic. And the conspiracy bore fruit, the judge says. There was disruption on the M25 on 4 successive days, from the 7th to the 10th of November inclusive. Over 45 protesters climbed or attempted to climb up the gantries at various points on the M25. Every sector of this orbital motorway was affected. Now, most of you would be familiar with the M25, and particularly those of you that live in London will be aware of the disruption that this caused around the whole of the M25 orbital circling London. For those international viewers that are not familiar with the M25 is a main motorway for vehicles that goes all around London and is usually very, very busy at the very best of times. Moving on, the judge says this disruptive protest action was under the auspices of an organisation now well known called Just Stop Oil, of which you are all committed activists. These protests caused massive disruption. The Police and National Highways Limited, the public body which owns and is responsible for the running of UK motorways network, had no choice but to close large sections of the motorway each day, causing long tailbacks. Now, there are long tailbacks on the motorway at the best of times, as I said. The judge goes on. At trial, the jury heard evidence quantifying the huge disruption caused. The total road impact time over the 4 days was 121 hours and 45 minutes. The total extent of delay to road users is calculated at 50,856 hours, and the number of affected vehicles at 708,523. The total economic cost of the 4 days of disruption is put at £769,966. Costs incurred by the Metropolitan Police alone, 5 other forces were involved given the geography of the M25, was over £1 million. And the jury heard evidence of the impact of the protests on ordinary members of the public who were travelling on the M25 on the days in question and became caught up in the disruption. Now, this is where the judge really gets into the meat of why these sentences were justified. So to reiterate, the jury heard evidence of the impact of the protests on ordinary members of the public who were travelling on the M25 on the days in question and became caught up in the disruption. That included evidence about the following: people who missed flights, people who missed funerals, school students delayed for their mock exams, a child with special needs on his way to school who missed part of the school day and his medication, which placed the taxi driver driving him there at risk as the child could become volatile without his medication, other school students with special educational needs being delayed on their way to school, somebody suffering an aggressive form of cancer who missed an appointment at a cancer clinic and had to wait 2 months for a further appointment. Now, on that point, I have seen some commentary that might have been one of the points at which the judge felt that this really crossed a line. If the others weren't bad already, somebody suffering from an aggressive form of cancer, missing an appointment, having to wait a further 2 months is quite grotesque. People who were late for work and had to work extra hours without pay to make up for the time. A heavy goods vehicle driver unable to deliver a £5,000 worth of food to a hospital, which is another one of the points that I've seen commentary on. And perhaps ironically, given the causes you espouse, the judge says to the defendants, an individual invited to answer questions at the House of Lords before the all-party parliamentary group for water, who was unable to attend the meeting and incurred wasted expenses. Although thankfully no major road traffic accident occurred, a police motorcyclist who was on duty dealing with a disruption on one of the protest days was knocked off his motorbike. His injuries were thankfully not the most serious, although he did have to take several days off work, but the bike was written off, worth more than £13,000. The crucial evidence presented to the jury at trial came in the form of an audio and video recording of a Zoom meeting a few days before the protests began. This is the Zoom meeting that I was referring to earlier. All 5 of you spoke in that meeting. The audience was activists from Just Stop Oil and other groups who were to take part in the disruption or were considering doing so. The recording revealed how intricately planned the disruption was and the level of sophistication involved. The Zoom call had been preceded by several others, and it revealed the existence of the detailed arrangements for the training of those taking part in the disruption, including an 8-hour climbing training session, resilience training, and even the provision of legal advice. And so within this Zoom call, they were discussing detailed arrangements of training sessions for an 8-hour climbing training session, resilience training, so to stay there for as long as they can, and even the provision of legal advice. So this very much was the conspiracy to cause this disruption under this legislation. The Zoom call recording also reveals how deeply involved in the conspiracy each of you was. You 5 were the people who spoke on that Zoom call because each of you was a key organizer of what was to come. The Zoom call came to light because Scarlett Howes, a journalist of the Sun newspaper, joined the call, pretending to be somebody interested in participating in the protests. So undercover journalism. She was able to record the main part of the meeting. She left at the point where participants went into breakout rooms, and what she had recorded was passed to the police. It was clear at trial that none of you think much of the Sun newspaper. And just as an aside, I've been contributing to several articles in the Sun just recently about motoring offences. I'll link 1 or 2 of those below. Go and have a look and you'll see my views there. So jumping back, it was clear at trial that none of you think very much of the Sun newspaper or of its proprietor. I make no comment about that, but what I do say is that Miss Howes and her newspaper did entirely the right thing by passing the evidence she'd gathered to the police. So I will pause for thought there and say I would hope nobody criticised the journalist for passing that information to the police, because that was, in my view, the right thing to do. Passing evidence to the police, such as filming a driver breaking the law and passing that information to the police and then reporting on it so that the public is aware, is all in the public interest and overall the right thing to do. Even if you don't agree with the offences, the principle of reporting it is still the right thing to do. Moving on. Had that not been done, the judge said, I consider it likely that the disruption would have been even greater than it was. In summary, your individual contributions to the Zoom call were as follows. Roger Hallam, you gave what might be described as quite a lengthy pep talk to those on the call, explaining why participation in the planned protest was necessary and justified. But what you said revealed firstly that you were at the very heart of the planning, and secondly, just how far the disruption was intended to go. I will come back to that. Daniel Shaw, you chaired the meeting, and what you said showed that you were intimately involved in organising the recruitment and training of protesters. Louise Lancaster, Lucia Whitaker-Diabru, and Cressida Gethin, your role was to inspire would-be climbers of the gantries by describing your own previous experience of similar direct action protest. And in what you said, each of you also revealed your familiarity with the detail of what was planned, and your enthusiasm for it. After a bit more discussion about each of those, the judge then says the offending of all 5 of you is very serious indeed, and I've previously made clear to you lengthy custodial sentences must follow. The individual culpability of each of you is very high. There is no definitive sentencing guideline for the relatively new statutory offence of causing public nuisance. So those of you that are not familiar, sentencing guidelines are the starting point and how a judge will analyse what sentence is appropriate for the relative offence. But there is, the judge says, nevertheless, guidance to which I have regard. There is the general guideline on the overarching principles of sentencing. I remind myself of the statutory purposes of sentencing, now to be found at section 57 of the Sentencing Code. And there is the recent decision of the Court of Appeal, Criminal Division in Crown, Trowland and Decker, 2023. That was an appeal against sentence for a substantive offence of causing public nuisance. It involved protest action very similar to that with which this court is concerned, and which occurred only a month or so before you offending. Further down, the judge addressed the aggravating features. Those are those that make a sentence worse, i.e. the features of the case or the behaviour that makes the offending worse and thus increases the sentence. The judge identified those as follows. The very high level of disruption caused to the public, the even higher level of disruption intended, the harm risked by the disruption to users of the M25 through road traffic accidents, and also to members of the emergency services whose duty it was to bring the climbers down from the gantries, and to the climbers themselves, whatever safety precautions may have been contemplated by the conspiracy. The fact that, as you all well knew, anybody climbing the gantries over the M25 in November would be in breach of at least one injunction granted in favour of National Highways Limited by the High Court. The fact that each of you has previously been convicted of one or more offences in relation to direct action protest. And finally, the fact that each of you was on bail in respect of at least one other set of proceedings when you committed this offence. The judge went through any previous convictions, suspended sentences, community orders, etc. with regard to the defendants, and then confirmed as follows. Each of you will serve up to half of the sentence I'm about to impose in custody, and will be on licence and liable to recall for the balance of that sentence. And so just to explain that for many people that might not understand it, when you get a custodial sentence, you will as a standard serve half of it in custody and the remainder on license. So in essence, if you get a 5-year prison sentence, you serve 2.5 years in prison and you come out and you're on license for the remaining 2.5 years, meaning that you can be recalled to prison for the remaining 2.5 years. For example, when a judge imposes a life sentence with a minimum term of 20 years, it means they will spend 20 years in prison and they are on license for the rest of their life, hence life sentence. So they can be recalled to prison at any time for the rest of their life. That's why it's called a life sentence, and that's why they don't spend the whole of their life in prison, unless they get what we call a whole life term, meaning they will spend the rest of their life in prison. Moving on to the sentences in this case. Just before passing sentence, the judge said there are other trials to follow in respect of the same events in 2022. The sentences I'm imposing are not intended to create any sort of fetter or precedent for any future sentencing exercises there may be. In other words, these stand on their own and future cases will be decided by themselves. This is the judge making clear that this has been decided on its own. A longer sentence is called for in your case, Roger Hallam, reflecting my conclusion that you were at the very top of the tree so far as the conspiracy is concerned. As to you, Daniel Shaw, Lucia Whitaker-Diabru, Louise Lancaster and Cressida Gethin, there are various differences in your personal circumstances and antecedents. But I've concluded that there are no grounds for differentiating between you four in terms of sentence. In your case, Roger Hallam, the sentence is 5 years imprisonment. In your cases, Daniel Shaw, Lucia Whitaker-Diabru, Louise Lancaster and Cressida Gethin, the sentence is 4 years imprisonment. So whilst on the one hand, many people might be saying that this was just a Zoom call or just a non-violent protest, let's just remind ourselves of the key points, in my view, that others have quite rightly raised, again in my view, the outline of the disruption that the judges relied upon in passing these sentences. And this, as you can well imagine, is not the definitive list of the disruption that happened on that day. It's just that the judge summarized and said that evidence that the jury heard included the following: people that missed flights, people who missed funerals, school students delayed for mock exams, a child with special needs on the way to school missed part of the school day, and medication placing the taxi driver at risk because the child could have become volatile without the medication. Other school students with special educational needs being delayed on the way to school, someone suffering from an aggressive form of cancer who missed their appointment and was delayed for 2 months, lots of people late for work and had to work extra hours, an HGV driver unable to deliver £5,000 worth of food to a hospital, and ironically, somebody disrupted from attending the all-party parliamentary group for water, an environmental concern. So these, if you take any view or you cast any view about these sentences, whether or not you agree with the greater concerns about climate change or not, I thought it was important to go through those sentencing remarks in detail because I feel that it hasn't really been covered in a great deal of detail by most of the media. And so I hope that was informative, useful, interesting. Please do subscribe to my channel and like the video to help my channel grow. And with that, I thank you for watching. I'll see you next time.